Hello, John Dove here, and welcome to episode 36 of the Speed Mooting Partners in Crime podcast. Today we had a nice long episode, but we actually only spoke about a few topics, and that's because we spoke about these topics in a lot of detail. So we spoke about one of the simplest forms of advocacy you might come across, but is actually very, very common, particularly for those very early in their practice, either as paralegals, solicitors, or even barristers, and that is the infant settlement hearing. So we spoke all about what this type of advocacy is, where it is conducted, and how to go about conducting that piece of advocacy. Hayley and I then spoke in great detail about our time as paralegals. Now, many of you entering this profession won't get in on the first time of asking. We certainly didn't. And therefore, many people will spend time doing some form of paralegaling. So we spoke all about what this role entails and why it is important in developing you as a lawyer and, of course, building character. We then spoke about some of our upcoming events at the Advocacy Club and speed mooting generally. So it was a good episode, we enjoyed recording it, and welcome to the podcast. We are live.
Hi everyone.
Hello, welcome to the podcast. I'm John.
And I'm Hayley.
And this is the Speed Mooting Partners in Crime podcast, episode number 36.
I'm glad you're keeping track because I am starting to lose track. We've done so many.
It is tough, isn't it?
Yeah.
Thankfully, I'm always just remembering, what was the last one? And part of the reason we're keeping track is because we name each of our episodes after a Formula 1 driver, and if not a Formula 1 driver, an athlete. So I always remember the last one, and part of the reason it's so easy to remember at the minute is because the 30s are rubbish for Formula 1 drivers. There aren't many. And are we cheating this week? We're kind of cheating.
We're expanding the parameters.
We're expanding the parameters because, so typically what we'll do is we'll use a number that's been used by a Formula 1 driver during racing weekends or during a race, if I put it this way. We're scraping the barrel this week because number 36 was used by a Formula 1 driver in 2 practice sessions. So for those of you that don't know what happens during a Formula 1 weekend, you have 3 practice sessions, so 2 on a Friday, 1 on a Saturday morning. You then have qualifying, you then have the race. And sometimes what a team will do is they'll use a different driver for a practice session, and then the regular drivers do qualifying in the race, etc. Long story behind it, not going into why they do it, but it happens.
I don't think you need to go into it.
We don't need to, but the long and short is, when that, say if you've got a non-regular race driver that goes in the car for the free practice session, they'll put their own temporary number on the car if they're not a regular driver, or if they do have a proper F1 number for whatever reason, they'll put it on. So, to cut a long story short, there's a driver that did 2 free practice sessions with a certain number. He then did become a regular race driver, and he does have a regular race number, which we'll come to in, it's going to be over a year before we come to.
Wow.
So that probably gives you an idea of what his number might be, or like how high his number was.
Yeah.
Well, I'll tell you. He had number 99.
Wow.
Yeah, number 99. So it's going to be...
Can he go into the hundreds?
No, 99's the top. And there's 2 drivers that have used 99 actually.
Okay. Save that for episode 99.
We'll save that for episode 99. So you're going to have to wait quite a while. You're going to have to wait.
I thought you were going to do the maths.
Yeah, I was going to do the maths. So 99 minus 36 is 63, isn't it? So you're going to have to wait 63 weeks for this answer.
That's over a year.
Over a year. That's well over a year. That is like a year and 3 months. So
if you are still with us for episode 99,
so
wow.
This is literally a slow burn story because I'm giving you the start now. You're going to have to wait until about April of 2026 to get the punch. Well, it's not even a punchline, just to get the end of this, and it's probably not even worth it. But anyway, long and short, I'm going with a driver that did 2 free practice sessions, Antonio Giovinazzi.
Never heard of the guy.
He's an Italian.
I got that, yeah.
Actually, interesting story about him. So he's driven for, I So he drove for Sauber in Formula 1, and he drove for Sauber in these free practice sessions when he wore number 36. Had number 36 on his car.
Yeah.
So he's within the Ferrari stable because he's done pre-practice sessions for them, and following his release from Formula 1, drove for Ferrari in their first ever entry. Well, not first ever, but first for many, many, many decades. Entry in the LMP1 category, top category, Le Mans 24 Hour. What did he do, Hayley?
Did he win?
He won the race.
Woo!
Oh yeah, there was something very special. I remember watching the end of that. There was something special about Ferrari winning at Le Mans, and I think because it was last year, because I'm not I don't watch Le Mans all the time. I just flick it on every now and again, and I think it was the 100th anniversary of the Le Mans 24-hour race. So there's just something special about Ferrari for the first time in many decades putting a car in the top category, winning the 100th one. That was something about that, and Antonio Giovinazzi was one of the drivers. So that's Antonio Giovinazzi, number 36. We've got to give a special shout out as well because
I know as well, yeah.
I have to say, I'm not that much of a nerd that I could remember that Antonio Giovinazzi used number 36 for 2 free practice sessions. I did have to Google it, and Wikipedia came to the help. And I also punched in onto Google famous athletes that have worn number 36.
You'll never guess.
You're never going to guess this. This guy got a mention. Well, he had an episode dedicated to him, I think 2 episodes ago.
Wasn't that long ago.
It wasn't that long ago, because I can remember it. So I think it might have been 34. This chap in the year 2011 wore number 36 for the Boston Celtics. I'll give you a few seconds to have a little think.
Shaquille O'Neal.
Shaquille O'Neal. He's had 2 specials in the space of 3 weeks.
It's because he's so big, he needs 2 episodes.
He literally needs to. I'm sure he's going to have another episode at some point, to be fair.
Probably.
He's a larger-than-life guy. He needs more than 1 episode. He probably,
Indeed.
as you say, he probably needs more than 2 episodes. So, welcome to episode 36, the Antonio Giovinazzi and Shaquille O'Neal special.
Welcome. And...
I was about to say, so I just had to laugh because, obviously we're not massive sports people anyway. We're not massive American sports people, but just seeing the Boston Celtics just reminded me of that episode of Frasier where we're talking about new Frasier now that's on Paramount, and he keeps going to watch the Boston Celtics play, and he keeps calling them the Celtics, and his son's cracking up. No, it's not the Celtics, it's the Celtics.
Oh, that sounds something I would do.
Yeah.
For the longest time when we first started dating, I used to call Sebastian Vettel Kel.
No, you couldn't remember his name, so I said you keep...
Yeah, that's what I mean.
Oh,
so I
yeah,
called
of
him
course.
Kettle, didn't I?
Yeah, you did,
The
yeah.
guy, the kettle guy.
The kettle guy, yeah, the kettle guy.
Seems crazy to think now that I would, didn't know who Sebastian Vettel was and couldn't remember his name.
It's like, when you think, 6 years ago, to you, Formula 1 was Lewis Hamilton.
Yeah,
that's it, isn't it?
Yeah.
It's like...
and I wouldn't even, if you pointed out, a Formula 1 car, I probably wouldn't even know that was a Formula 1 car. I just knew they drove fast cars.
Yeah, I suppose if you saw it, you'd have gone, what's that spaceship looking thing?
Yeah. I mean, we've seen them in real life, haven't we? And they're so big in real life.
It's crazy how big they are. Apparently they've grown quite a lot, though. Like, if you saw an F1 car from 20 years ago, they're probably about a metre shorter, maybe more.
You know what else we saw in real life recently, and I was surprised by how big it was? The jet. Do you remember we were driving down the motorway and we seen a fighter jet? Is that what they're called? Fighter jet. A fighter jet.
I can see the confusion because it does go into flight, but yeah.
A fighter jet.
Fighter jet.
And it's so big. When you see them on Top Gun and stuff, I thought they were quite small and compact, like a car maybe.
God.
They were massive. They were as big as this living room, which you can't see, but they were big.
Yeah. I mean, when you think about it, it needs to be a decent size because you've got a jet engine strapped to it, haven't you? So.
Yeah, but that doesn't compute in my brain. I was like, whoa! It was like being towed on the back of a truck.
And ironically, what you saw, that's a relatively small one. Like, if you saw the Eurofighter Typhoon, that would be massive.
Wow.
That's pretty much... Well, I don't know if it still is, but that's pretty much the creme de la creme of fighter jets.
Ooh.
Yeah.
Oh. We have Prime pulling up outside our
Prime.
house, and I am waiting for delivery, so
am I.
bear with us.
Hello,
John.
So,
what have you just had delivered?
I have just received a book. It's from a chap, Dr. Mark Hyman. Give him a shout out there. I was listening to him. He was on the Tucker Carlson podcast, I get loads of random podcasts suggested to me. So I've never really listened to Tucker Carlson, but he had Dave Ramsey as a guest, and I thought, Dave Ramsey's on there, I've got to give that one a listen. So Spotify keeps recommending all these episodes. I've not really listened to them, but I saw Dr. Mark Hyman was on there, and I listened to, well, actually, no, I didn't listen. I read one of his books years ago, and
so what is he, like a nutritionist?
He's a doctor, but he very much talks about sort of alternatives. He says that he talks about the pharmacy, as in like FARM rather than PHARM. And what he says is, he says that your food can be your medicine, basically. Obviously he accepts that there's a place for medicine, but he says that if you change your diet and the way you go about things, there's a lot of illnesses and the like that can be avoided. Wow. He says that he says that the modern diet is affecting us in a massive way, and he talks a lot about autoimmune conditions. And I have some people may know I have a thing called iritis, which is an autoimmune condition. So
you also have your eczema as well, which is another form of it, isn't it?
Another form of
inflammation,
which is a form of inflammation. So what he talks about is within your diet you can massively improve inflammation and autoimmune conditions and the like. So I thought it's worth a go.
Of course it is, yeah.
So I'll have a little read of his book, see what it's all about, see if I can shake the diet up a little bit and improve things. And what's the worst that happens? I waste my time reading a book. So
it's never a waste of time to read a book.
It's never a waste of time to read a book. So I thought, yeah, let's take a little listen to the book. Let's see what. Take a listen to the book. Maybe that's a sign I need to change my diet. The diet's affecting the brain. No, so I thought, let's take a read of it. Let's have a little see. Let's see if there's any major changes we can make in the diet, and let's see if it can improve the autoimmune and all the rest of it. You have
to come back and give us a little what you've learned afterwards.
Maybe on episode 99 when we're talking about Giovinazzi again, I can give you guys an update.
I don't think it will take you that long to read the book.
Oh right, sorry, I thought you meant in terms of telling you what the outcomes are and all the rest of it.
No, just to the book.
Yeah, definitely.
For now.
Yeah, absolutely. So I thought it's worth a go. Let's see what it's all about, and nothing to lose.
There we go.
So
anyway, back to where we podcast. So if you've listened to this so far, you might not have a clue what this podcast is actually for.
Yeah.
So
you'd be shocked that it's a legal podcast given what we've been talking about for the last 10 minutes.
Yes. But it is called the Partners in Crime, the Legal Podcast. So John and I are both lawyers. Yeah. I'm a solicitor. John is a barrister. Yeah. And we're here to help junior lawyers and aspiring lawyers in any way that we can. So that can be through training and education, commercial awareness.
Awareness. Is that awareness, the plural of awareness?
Yes, that's what it is. Commercial awareness and insights into the law and the legal industry.
Yeah.
We answer your questions. That drives a lot of our content. So if you want to ask us a question, you can email us info@speedmooting.com.
Yeah.
You can also leave us a comment. So if you're listening to this on Spotify, leave us a comment. If you're listening to this on YouTube, leave us a comment. You'll find us on every single social media platform that exists.
Yeah.
Leave us a comment, drop us a message. We love engaging with you all.
We certainly do.
And if you want a good overview of what Speed Mooting does as a business, because there's a lot that we do, have a listen to last week's episode 35.
Yeah.
We gave a big overview of all the things that we do, being our competitions, our advocacy training, our advocacy club, and all of our events. So have a gander at last week's episode if you're new to this podcast.
Absolutely. So as Hayley says, we talk about so many different things, and we tend to have different segments on the podcast. So we have Learning the Law, we have our Commercial Awareness Corner, we answer your questions, etc. So I thought we'd start this week with Learning the Law.
Yep.
And as Hayley says, I'm a barrister specialising in crime, so almost all of my Learning the Law segments have been on crime. I'm going to take a bit of a deviation this week and go back to civil.
Okay.
So the reason I'm going to talk about civil litigation, civil law this week is because I spent many years working as a paralegal within a firm that specialised in personal injury, and of course that covers or falls within the remit of civil litigation. And as some of you may or may not know, paralegals can conduct advocacy in district judges' chambers. So these are closed off hearings, not open to the public, and they tend to be smaller type hearings, if I put it that way. So applications and things of that nature. I think even small claims trials might even take place in district judges' chambers, and that's why people who aren't qualified as barristers or solicitors can do small claims trials. So I was entitled to do advocacy, and the first piece of advocacy I was ever given was an infant settlement hearing. Very common, lots of pupil barristers do them, lots of trainee solicitors do them, lots of paralegals do them, your county court advocates do them, etc.
Yeah, I was just going to say, we've got an episode coming out soon with a county court advocate, and that's what she said it was the first thing that she was doing, was these types of hearings.
Absolutely, so very common. And when I was first instructed to do one, and the night before I had all the papers, I'm preparing for it, and I had no idea whatsoever, what happens at one of these hearings, what to say, what to do, etc. And I'm doing all this research online. There was nothing. I thought, let's go on YouTube, see if there's some sort of instructional video. There was nothing. And I ended up ringing up a barrister mate of mine, and he did crime and then moved into family, so it wasn't really his remit, but he was having a chat with me, and long and short talked me through it and said, don't panic about it. But even still, the point still stands that there was very little, if any, information online about it. And I was going in blind, I had no training on this. And it would have been helpful for me to have something, so I thought, let's put something out there, let's talk about it. Because I imagine there are many people in that same situation as me, panicking, not knowing what to do, so let's try and put some information out there. So, first things first, let me tell you what an infant settlement hearing is. So, these take place when you've got a child that is involved in litigation. Typically, the situation tends to be a child that's involved in a road traffic accident. So let's say, for example, you've got a rear end shunt, so one car goes into the back of another, and there's a child in, let's say the child's in the front car, so the non-fault party.
Yeah.
It could be an either, because
either way, of course.
The child would be entitled to compensation, even if they're in the fault car, they'd sue the driver or what have you, but either way, for ease, let's put them in the front car. So the child's involved in this, and all liabilities accepted, and then you need to agree a settlement. So this isn't a case that's gone to court, this is a case that's just settling between the parties. And let's say the child has, 2 months worth of soft tissue injury. I'm picking figures out the air here because it's years since I've done civil litigation, so I can't remember what the matrix says, what they'd be entitled to, so I'm picking a figure out there. So let's say it's 2 months worth of soft tissue injury, and a settlement is reached whereby it's £2,000 worth of compensation.
Yeah.
So what would happen is you'll have some negotiation between the claimant solicitor, so the child solicitor, and the defendant solicitor, and they've agreed on this price. So the child would have a litigation friend, and that's someone that's doing the litigation on their behalf, so corresponding for them. Usually tends to be a parent, because it could be an 18-month-old baby. An 18-month-old baby can't be signing contracts and doing all that. And even a 17-year-old individual, they're still a child, they can't be doing this on their behalf, so they still need a litigation friend that is their conduit between them and the solicitor or what have you.
Yeah.
So, given that individual is not legally trained, whilst they can say, yeah, we're happy to accept the offer, the court wants to know that it's in the best interest of the child. So what would happen is, once you've got this settlement, it will go before a district judge or a deputy district judge for a very straightforward hearing, just for the judge to look at the facts of the case, look at the facts of the injury, etc., and say, yes, I believe that this is a reasonable settlement in all the circumstances. So what happens is, when you're listing this hearing, the claimant solicitor will send a series of documentation off to the court. So the court will see a form, effectively, like a claim form. They'll see an advice from counsel, because whenever you have a child and they're going to be agreeing a settlement, the solicitors will need an advice from counsel just to say, yes, this is what you should be settling the claim for. Yeah. This is what it should be. You'll have a medical report. So what would happen is, at some point during the proceedings, the child will have gone off to see a medical specialist. The medical specialist will have assessed the child and will say, yeah, this is the prognosis, this is how long you're likely to be in pain for, etc. And so all of these documents will be sent off to the court. So as the advocate, what you will do is, you need to be effectively persuading the court that the settlement is reasonable.
Mm-hmm.
And what you're armed with is your advice from counsel. So counsel might say, I've seen the medical report, the prognosis is 2 months, based on a prognosis of 2 months soft tissue injury. It's not 2 months in every case, I'm just using this as a
fine, we
example.
Get it.
So based on 2 months worth of injury, the matrix that's out there says that the claim should be worth between this and this. So they might say in this example it's $1,500 to $2,500. Therefore, I believe a settlement of $2,000 is right bang in the middle, and therefore that's a reasonable settlement. So let's try and go for that. So at the hearing, you will start with the same courtesy you would do always. May it please the court, I appear on behalf of his child through the litigation friend. Firstly, bit of courtesy. Sarah or Mom, have you seen the papers? Or it's judge these days, isn't it? Have you seen the papers? They'll say, yeah. And then set out the facts. So the background facts to this case are that on such and such a date there was a road traffic accident of this nature. The child I represent had X, Y, and Z injuries. The prognosis within the medical report said that these injuries may last for 2 months. This was the length of the injuries. They didn't go beyond that. There is an advice from counsel. The advice from counsel says that the value of the claim will be between this and this. On such and such a date, we settled for this amount. In the circumstances, I would invite you, Mom, to make a finding that this settlement is reasonable, unless I can assist any further. So it's really, really straightforward. The advocacy is quite simple.
What type of, if any, questions, judicial intervention can people expect?
So sometimes what it might be, so let's say you hadn't covered any of those points, the judge might ask about how long the injuries actually did last for, whether there were any particular complications. They may ask about that. The other thing they might ask is whether they want the money on trust. So sometimes, this is me thinking back now, what they might say is they'll say, right, we'll keep this in a trust fund for so many years up until the child is 18. Or there were occasions, if I remember rightly, of course I'm talking about advocacy I was doing 10 years ago now, I think that on occasion if the settlement was very, very small, or if the child was, let's say, 16, 17, it's not going to be on trust for very long, the judge might say, would the parents like the money at this stage? Because sometimes they can do that.
So it's almost like tick boxy, like a checklist that the judge is taking you through. So they'd only ever ask questions if there's something that you've missed, and it would be something that would be so common in these cases that you would have the instructions.
Have the instructions.
It's not like other advocacy where you're like, oh God, I don't know the answer. That's why it's so straightforward and a good thing for juniors and paralegals to do.
And generally speaking, you would have the litigation friend in court with you anyway to ask these questions of. There were occasions when I would do it in the absence of the litigation friend. So sometimes they'd be there, sometimes they wouldn't. But 90% of the time, the litigation friend tended to be in court.
Yeah.
Now, you were asking about judicial intervention. One area where you may get some judicial intervention from would be in relation to the paperwork if there are any mistakes. So check everything very carefully, because you'll have the birth certificate, because that's required for this, and this will be part of your paperwork. It might be an approved copy, a certified copy, etc. But you'll have that within the paperwork. So check the claim form and check it against the birth certificate. So, for example, check that the name matches up, check that the date of birth matches up, for example, because sometimes you get judges that are very particular, and they will say, well, the claim form doesn't match with the birth certificate, therefore I can't open a trust today, therefore we need to adjourn and bring this back to court. You'll fill in the paperwork properly and get that done. So
but that's the worst thing that could happen if there's something there that's wrong, or because I'm just thinking if this was me, this is what I'd want to know. What's the worst thing that could happen?
What's the worst that can happen? Yeah,
they'll adjourn it to another date.
That's it. The worst thing is they'll adjourn it. The judge isn't going to say, no, I'm not going to approve this, and no, you're not getting the money or anything.
I'm throwing this entire case out.
No, it's not going to be that. It's going to be an adjournment. But what you can do is you can ask the judge to say, well, may we amend the claim form administratively in court now, or slip rule, what have you. Some judges will allow that, some judges won't. Some judges say, no, I want all the paperwork correct in front of me beforehand.
Yeah.
And that's just to give an example of a bad experience, that's what happened the first time to me. So I'd literally spent hours and hours and hours preparing these. What you'll find is once you get into a flow...
Yeah, they're so simple.
These are so simple, they'll take you 5 or 10 minutes to prepare. But when you're new, as you would always, you're going to be spending hours going through these. So I'd spent literally about 3 hours prepping this, doing all my submissions, all this, that and the other. And I go into court and I made all my submissions, you'd have thought I was in the Court of Appeal or something. And the judge goes, well, Mr. Dove, I can't approve this today. Why can't I approve this? I was like... I'm sweating at this point, thinking, what on earth have I done wrong? What have I said wrong? How have I cocked this case up? Sir, I don't know. I'm afraid I can't assist. Mr. Dove, take a look at the birth certificate. Mr. Dove, take a look at the claim form. Names don't match, do they? And what had happened was the middle name had been missed out on the claim form. Says the middle name isn't on there. Go back, tell the file handler whose case this is that they need to amend this and submit an updated application to court, and we'll bring this back for another hearing and we'll hear this again. so literally my first ever hearing, and that went wrong. So all these hours and hours and hours and hours of prep.
But that's something you can't control, isn't it?
No, not at all. So
and I guarantee you, like, even if you were going through the papers during your prep and you just spotted this, the file handler probably, because I'm thinking from the other side, when I used to do mortgage repossession, it was very similar. It was tick box stuff, so you have to fill in a pre-action protocol and stuff. And if the advocate ever rang and went like, oh, it's number 21, the house, it's only you've put 2 or something, you go and see if you can get it through. So you would have been sent in anyway to do the same and ask for it to be amended under the slip rule. So even that must help a little bit. Like, that wasn't your
No. So
and you would have still been in the same. You would have
been in the same boat. So there's nothing I could have done. There was nothing wrong with my advocacy. Nothing I could have changed. It's a tiny point. It was just the way the judge was there, making me feel like and that those few seconds when you think, what have I said wrong? What have I done wrong, etc. So the point being, anything like that, you can always ask the judge to amend. The worst they'll say is no, adjourn it off. And I've talked about this from the point of, let's say if it's going to be, you're going to cover every point within your submissions. What might happen and what happens a lot with these, because you're going to be listed in a very, very busy
they'll have so many
court.
of them to get through.
What the judge will often say is, you'll open your mouth and the judge will say, well, I've read the papers, I've looked at the prognosis, I'm happy with the counsel's advice, I'm happy that this settlement is reasonable. Do you have anything to add? So your submissions might literally be,
Nope. Thank you, Judge.
Yeah.
So that's that would be so helpful to me. If I had to do, because I'm not an advocate, if someone said to me, that's where you got to start, I would want a video exactly like that, telling me what it is, what to expect, what I need to say, what I need to prepare. So hopefully that is really helpful for you beginner advocates out there.
That's helpful. And, off the back of that, if anyone's ever got any questions, always feel free to, from an advocacy point of view, we're not here to give legal advice or anything of that nature, but from an advocacy point of view, if there are any questions, fire us a question, info@speedmooting.com, and we'll answer this on a future podcast.
Yep. So I have a follow-up question.
Go on.
That will be helpful for people listening to this. A lot of people may know, but we always say, you don't know what you don't know.
Exactly.
So there will be people listening to this going, So what is the difference between a hearing in judges' chambers and hearing not in judges' chambers?
So judges' chambers simply means it's a private hearing. So you would think that it's a different physical premises. It's actually not. So
that's what I always used to think. Like, it was back in like the judge's office or something.
Because that's what you think. Particularly when you watch Suits or something and you're seeing an argument.
In my chambers.
In my chambers. And you go in and they'll have an argument. So it kind of is like that. You're having an argument in front of the judge in their desk in a little room in the background. But with this, there's no difference. You're not in a physically different place. You're still in the same courtroom. It's a closed-off private hearing, so it's not open to the public. So the only people that can be in there are the parties to the case. So the judge, the lawyers involved, the actual claimant and defendant if they need to be there for whatever reason. And that's pretty much it.
So the layout of the courtroom doesn't change, or you're still standing in the same place, you're still... So if you've watched people that have been in, like, observed court hearings that are obviously in open court, Is that what they can expect when they
That's
do
what they can
chambers?
expect. It's exactly the same. So you're in exactly the same courtroom. It's private.
Yeah.
The public can't come in. You mentioned about standing. You tend to sit in chambers.
Here we go.
So that's the other key difference as well. So the judge will be sat, and you will be sat, and the layout of the room, because it's in a sort of a civil court. So I'm thinking back to the days in Birkenhead County Court, and that's a massive centre for personal injury type stuff. The courtrooms are very small there. So it's imagine like sort of a kind of horseshoe type arrangement.
Mm-hmm.
So you've got your judge at the top, and then it kind of goes out and along like that, and a couple of chairs either side. So you are literally sat 6 feet away from the judge when you're doing your submissions.
I think that'd help though, because that'd make it feel less.
It feels a lot more intimate.
Yeah.
It's a lot less off-putting. So yeah, I think of Liverpool for example. So I used to. Liverpool and Birkenhead were the only county courts I used to go to because the firm I was working for was based in Merseyside, and Liverpool kind of was a much bigger courtroom that you'd end up in, but it was the same sort of situation. You'd just be sat there making your submissions to the judge. So the courtroom is exactly the same. It's just you're in chambers.
Yeah. There we go.
And I suppose it's the same in the Crown Court as well. So sometimes you'll say like a bail application is a private hearing, so the general public can't go in there. So they'll say the court is in chambers. So what will happen is, the usher will close the door, put a sign on saying in chambers, do not enter, and you'll just make your submissions there. Depending on the judge, sometimes you'll take your wig off.
Well.
Yeah. So it's very.
Do they say like you may unrobe or whatever it's called?
You kind of follow the judge, so you watch what the judge does. So I remember the first time I ever did one, and we just sat there. Next thing, judge comes in. We were the first hearing on, and so the usher does the usual, the usual sort of speech to open the court of a morning. Judge sits down, and then we'll hear the bail application.
So you copy.
And then I just followed suit.
That's clever. Yeah. See, again, people wouldn't know that.
No. So I always tend to go in with my wig on and just follow suit with what the judge does.
Yeah. That's a nice tip, isn't it?
Yeah.
It's probably like quite respectful as well to do that.
Yeah, I mean, it's one of those, you'll see different barristers have different opinions on this, so don't take my word as gospel. People will say different things about it. But yeah, as a general rule for the bail application, when I'm going into court, I'll go in robed and just follow suit with the judge. Yeah. Safe choice. Keep it simple. There'll be more senior barristers out there that'll say don't listen to John, don't take advice, etc. So, it's horses for courses.
Yeah. But I think it's logical what you do.
Yeah.
Makes sense. There we go. That is our Learning the Law segment.
That was longer than expected, wasn't it?
That was really useful, though.
Yeah.
Really useful. Like, if someone said to me, tomorrow you got to go do an infant, I'd be like, oh, let me go watch that video again. That's exactly, like, I didn't do much advocacy. We've covered this previously, but I had to do a tiny amount because it's part of your SRA requirements. Advocacy is on there. So you have to do some form of public speaking and advocacy. So I did one hearing as a trainee solicitor, and it was restoring a company to the register, like, so simple.
Yeah.
But that's what, like, I would have wanted, like, someone to sit me down. I think you did help me a bit and say, this is what it's going to be like. This is what it'll be like when you go into court. This is where the judge will be. This is where you are. This is what you need to say.
Yeah.
This is what you need to expect. Like, because as you say, it might be something so simple, but to you, it's huge. It's your first thing you're doing. So to have someone sit down and, like, tell you step by step, there'll probably be a lot of grateful people out there for that one, John.
Yeah. I remember actually restoring the company to the register, so I had to do one of those as well. And I was sent down to, might have been Derby, I can't remember. It was a fair old trip, to be fair. And so so I got to drive all the way there, good few hours and everything. And once again, all this prep that I'd gone into, because I'd never seen anything like this before. Go to court, go in there, and the judge literally said, Mr. Dove, yeah, I've seen the papers. I'm happy that this company needs to be restored. Anything to add? And I literally, I could have just said, yeah, thank you, walked out. I literally made sure I did about 2 minutes worth of submission, just for the sake of it, because I've travelled this far.
Typical John Dove.
Yeah, the judge was sitting there thinking, okay, yeah, fine.
Yeah. Mine was very similar in that I had submissions planned because I was so nervous. I'd written a script and I'd practiced it like 20 times, so I knew it off by heart. But when I got in there, the judge said, yeah, everything seems in order. Do you have a draft order for me to seal? And I was like, yes. So that's the difference between you and I. I was like made up that I didn't have to do anything. But you're like, oh, prepared this. I want to perform this.
Yeah. Actually, no, I'm getting confused now. The one I'm thinking of, so that wasn't me restoring the company, that was to come off record, actually.
Right.
Coming off record, but the same thing. Read the papers, happy to come off record. Anything to add? Yeah, let me...
And that's probably the difference between someone who should be a barrister and someone who's happy being a solicitor. Are you disappointed when you don't have to deliver submissions, or are you relieved?
Exactly, yeah, exactly.
Anyway, that's all in the law.
Yeah.
I want to move on because we've got another good segment today, and this is an insight for you all. So, John and I, again, we've covered this on previous episodes. John mentioned it briefly earlier, but we both come from a paralegal background.
Yes.
So we wanted to do a segment for you today for anyone who is considering a paralegal role, or who's finished university, finished postgraduate, and is looking for something to do while they wait for training contracts and pupillage, etc. A bit of an insight into what a paralegal is.
Yeah.
And that itself is a huge, like, how long is a piece of string, isn't it?
Well, exactly, yeah.
Because essentially, I mean, I don't know what the real definition is, but in my brain, if someone says to me, what's a paralegal? It's a non-qualified person that assists lawyers.
Yeah, that's it. You've hit the nail on the head.
And it can be, so I was a paralegal in mortgage repossession, so I had a full caseload because it was volume-based work, so I had about 400 cases at a time. So I was there doing the claim forms, doing the witness statements, running the whole files top to bottom. And then we had a supervisor that was qualified, and we had a non-standard team that was full of solicitors. That's where I ended up eventually. And we'd go to them if anything was non-standard. So we get defences in all the time that were very straightforward. Oh, yeah, I am in arrears. I can afford to pay this much. Okay, great, we can deal with that. Sometimes we get tricky ones like this whole mortgage was fraudulent. Okay, non-standard. So then we take it to the solicitors. But so I was a paralegal, but I was running a full caseload.
Yeah.
When I was a trainee in real estate, for example, we had a couple of paralegals, but they were working more side by side with the solicitors. So it was the solicitors' files, but then the paralegals would do the land registry applications or some really simple letters, or they take the telephone calls and stuff. So they're two very different examples of two paralegal roles.
Yeah, absolutely. So that's kind of what I did. So I think about it because I did a few different things when I was a paralegal, but I'll focus mainly on sort of the last aspect of it, the last year when I was a paralegal. So it sounds more like what you were talking about there, whereby we had one solicitor that basically had a caseload of files.
Yeah.
And then my job as the paralegal was to just assist and do whatever was necessary. So what tends to happen is, depending on the area of law, will dictate how many files a solicitor has. So, you could be doing road traffic accidents whereby, you could have 500, 1,000 files.
Yeah,
like
but
that,
more volume-based stuff is what I call it, yeah.
It could be, really bespoke, complex things where a solicitor's dealing with 10 files at one time. In I don't know what type of law that would be, but I'm sure there's areas of law where solicitors have literally just 10
of
files.
Course, yeah. Corporate,
what they're doing
that's
is,
a big example.
Yeah. So what we were doing was employers and public liability. So the solicitors tended to have a few hundred files at any one time.
Yeah. Let's just turn that fire off because I'm getting really hot.
Yeah.
So wait, it's right behind me. So solicitors tend to have so many files at one time. That's where you stop.
Yeah. So, within this area of law, your solicitors will have, a couple hundred files at any one time. And I should say we use case management software to manage our files. So it's not like you're just on Word and you're just opening files and folders. And
no, there'll always be some form of case management.
There'll always be some sort of case management system. And then what you'll do is during the life of a case, you'll know when various tasks need to be done. So as you say, a particular claim to be filed, or you need to do a schedule of loss, whatever it is. So you put these things into the diary system, and then each day you'll look at your task list and you'll know what you need to do on all your different files. And the nice thing was, you're covering so many different things. So it can be as basic as, well, you need to phone your clients up to take instructions, you need to phone them up and complete a witness statement with them. So that was quite an in-depth, detailed task where I'll speak to them about everything in detail and then type it up. And being a barrister, that was quite good because it worked on my witness handling skills. I was focusing on, asking them open questions and then, challenge them a little bit, so things like that. you would, as you were talking about, lots of drafting. So your particulars of claim, your claim forms, and what was quite nice actually was our team. We had sort of 4 within the team. So we had the solicitor that had overall conduct of the file. So they were like basically the supervisor.
Yep.
Myself as the paralegal that would do much of the sort of the bulk of the day-to-day work. We had legal assistants who could help with the kind of smaller things.
The admin-based roles.
Roles. And then a secretary.
Yeah.
And she was really good because she would run a lot of the bulk process and things. So, for example, a claim form, in the olden days, you have to print it, write it out and all that. These case management systems are so advanced that you kind of just go, punch a few things in and it just processes all of it.
Yeah,
so she was able to do all of those kinds of things. So we were a good little unit, a good little team that worked together. And, but the idea is here, as a paralegal, you're doing so many things and you basically are you are basically a solicitor without the title, in effect.
It's so valuable.
It really is.
The experience you build up, and especially a lot of firms. So, I mean, you might want to be a barrister being a paralegal, but if you want to be a solicitor, the majority of the large firms out there, they recruit externally as well, but they recruit so many internally. So if you've worked as a paralegal, people know how good you are and how hard you work. They want you back. They want you to be a trainee solicitor. They want you to qualify because they know how great you are in that department. Yeah, a team could not function without its support staff. No. So your paralegals, your secretaries are absolutely instrumental. I remember from when I was doing real estate when I was a trainee, the paralegal probably trained me more than the lawyers did.
Yeah,
like, I remember sitting there going, what's this Excel? How do I work this? It was the paralegal I was going to initially because they know more about how systems run, or like you say, the bulk processes and stuff. The secretary is the one you want. The lawyers will train you on the law, but on how an office runs and how this caseload runs, it's the support staff that are crucial.
Yeah.
Our partner, I guarantee, could not file a land registry application anymore. He could check it and approve it, but going onto the land registry portal and submitting it, not a hope in hell.
No.
Because they rely so heavily on the support staff. So it's so valuable. And when people see that on your CV, they know you've had real life experience and, it's built up your skill set so much. Yeah. So don't ever doubt how valuable a paralegal role is.
And it's kind of, it's almost like paying your dues in this industry, isn't it? People in the music industry and all the rest of it talk about it, but it's the couple of years where you're absolutely grafting, you're working so hard, you're learning so much about the law because it's how you initially put the law into practice for not very much money.
Yeah. Yeah, that is the big downside
because,
to it.
Because you'll notice, for example, I went from a paralegal role to then becoming a trainee solicitor, albeit in a different area of law, but doing similar sort of things. And then suddenly you qualify. Not a great deal changes about your job. Oh, okay, fine, I was going to court, but, not everyone does. But then you get this massive pay boost, and it's kind of, you're going, well, in reality, has anything much really changed from what I was doing when I was paralegaling? Partly because, I was in an area where I was given so much scope. As you say, Hayley, there's probably areas of law out there whereby there is more of a distinction between, what's done from when you're paralegal into when you qualify. Because
yeah, absolutely.
Particularly in the bigger firms, I would imagine, whereby there's, huge distinctions in the roles, and, as you become an associate and a principal associate, knowledge, you get more exposure to doing more things, that's fine. But in the vast majority of your firms, I'd say 80-85%, you'll get so much valuable experience as a paralegal, such hands-on experience of the law. So your paralegal experience, it's character building,
yes,
and you're gonna learn so much.
Yeah, and most firms will know as well what your overall ambitions are. So if you want to be a solicitor, for example, they'll be helping you, so they'll give you more responsibility. They'll let you go to court. They'll let you come into the client meetings and take a more active role.
Yeah.
They'll support you because they want you to grow and qualify and hopefully stay with them as a firm.
I think my client care skills have developed so much just from my years as a paralegal, because you'll find you spend so much time on the phone.
Yes.
So it might be, you're phoning up. I'm talking about it from a client care point of view. It's actually just general
communication skills, yeah.
Because you spend so much time on the phone. Clients phone up, I need an update on the case. and you give them the updates. Oh, well, what about this? What about this? What about that? What about the other? So you spend so much time giving legal advice, learning how to deal with people, you know, particularly if you're dealing with a broad range of clients.
You take it for granted, don't you?
You do take it for granted, but you think about, you know, I think about my first day as a paralegal, and I was given the task of ringing a defendant insurer to see if they've got a response to our offer. So it's dead straightforward. Hi, can I speak to someone about this case? Here's the reference number. Yeah, we sent an offer on this date. Have you reviewed it yet? No? Alright, thanks. That's how straightforward it is, and you think nothing of it. And they're like, and the person who was telling us going, do you want to watch me do one first? Yeah, alright, yeah. Can I watch you do another one, you know? And then, you know, you do that and that's nothing. And then you get to the point whereby, you know, a month in, you're just like, oh, such and such needs a call about this, yeah, fine. And so that's why, to me, making a phone call is nothing. Doesn't matter who it is. Yeah, I've got to ring this person, sound.
Yeah.
But you don't realise how far you've come. No. How, if you're not somebody who speaks on the phone all the time, why people are nervous about speaking on the phone.
Yeah. I remember when I was doing the volume stuff, so it was mortgage repossession, so it's changed now because they've got like call teams that deal with the calls, but way back, we're talking 10 years ago, your caseload, you dealt with all the calls as well. So the client with a bank, so you had to deal with all your client calls.
Yeah.
You had to chase the court constantly about your files. Then you had to take the calls from the borrowers as well. So you'd have people like the worst moment in their lives, you know, the house is about to be repossessed, you had to deal with that.
Yeah.
And then when I crossed over to be a trainee, and it was like, oh, you might have to deal with some difficult conversations. Sometimes the clients aren't happy with you, and it's like, I've just worked for years and years where no one's happy with me, so I can deal with it. But you don't appreciate, like, oh, that's a massive skill.
Yeah.
Because I was doing that all day, every day. You don't get, like, scared by the hostile conversations. It's like, yeah, I can take someone that's not happy, or I can talk to an opponent. Of course I can.
Yeah. It's one of those, isn't it? Yeah, and that's kind of the thing, isn't it? You get to the point where you know how to manage clients as well. You're on their side, you're the one that's fighting their battle for them.
Yeah.
And then quite often, you know, it's, you guys are doing nothing. It's like, no, this is the process. This is why, you know, it takes time for this.
Yeah.
They think they probably got suits where like every case is settled in one.
Yeah.
The case goes from the thing happening to the case settling or having a trial in 1 week. And no, it takes time because we've got to serve this, and they get so long to respond, and this and that.
But now it's another good example. That's why I bring it up, because I was essentially trained on how to deal with difficult conversations without ever thinking that I was.
Yeah. But you know, you're fighting the other side and fighting your own clients at the same time.
And that's just a big lesson to learn for life in practice anyway.
Yeah.
So many clients, especially when you work in like litigation or road traffic, medical negligence, etc., because they're coming to you because something really bad has happened to them that they need you to fix, and sometimes there's not a fix, or it's not the fix they want. Like, so many people, like, you know, want the day in court, and you have to explain to them, no, you need to settle. I want take this beep to court, and it's like, yeah, you might do, but it's going to triple your costs, and this is a great outcome. So we're like, yay, settlement! And some clients are like, oh, I wanted to win. Like, you have won. Like, of course you've won. And it's the same with the other like grueling stuff. Imagine if you work in like mergers and acquisitions and stuff, it's probably not quite as bad because you're just helping people make more money, or
and your client base, I suppose, the more used to dealing with professionals, so they understand.
They understand the time limits and time scales, and But so it's another valuable lesson you'll learn as a paralegal is that clients sometimes aren't happy with you, and that's okay.
You have to learn how to deal with angry people.
Yeah. So again, that was a really long segment, but we just wanted to give an insight into the paralegal world and to completely recommend it. I got my training contract internally. I was a paralegal at the firm for many years beforehand, and some firms only recruit internally. So I know Freeth, who I worked for as well, so they make their trainees, you have to work as a legal assistant for a year first. Yeah. And then start your training contract.
Yeah, I suppose, I mean, this wasn't the purpose of this segment. The purpose of this segment was just to explain what a paralegal role is, because many people might be at the point where they're thinking that, you know, need to apply for those soon, etc. But I suppose, you know, just to underline this, if you are someone that doesn't get, you know, straight away, doesn't get your training contract, doesn't get your pupillage, and then you have to go and paralegal for a year, 2 year, 3 year, 4 years, whatever, don't worry, because you're going to build so much character during that time, and it's going to advance you so much in your career. So don't panic about that at all. It's gonna help you.
Yes.
In the long run.
Absolutely. Wow.
We got time for a question, Hayley?
I don't think we do. We're on 54 minutes.
Okay.
So we'll leave that question till next week. We've got a lot of questions to get through. But we will be answering loads in our pupillage Q&A panel coming up.
We certainly will.
So we'll just do a quick recap of our events and then we'll finish it here for this week, I think.
Perfect. Okay. So coming up this month at the Advocacy Club, we have our special Advocacy Club public speaking special.
The festive meeting.
Christmas jumpers are actively encouraged.
Christmas jumpers, mince pies, a tipple of your choice.
Yeah,
all welcome.
If you want. Anything goes. Well, not anything, but
within reason.
Yeah, let's make it a celebration. Let's have a fun one.
Yeah, I was thinking about this, so it's essentially it's a public speaking meeting, isn't it? So people talk about whatever they want. Festive talks are encouraged.
Yeah.
We should think of something else fun to do. I don't know, just drop in a couple of festive jokes periodically, or some sort of festive public speaking game or something.
Yeah, we'll think.
I'm going to put my thinking cap on and think of some extra funny bits for this meeting, I think.
Definitely. But
this is one of my favourites. So we usually have 2 a month, don't we, John? But this month we just have one. We bring everyone together for Christmas, and it's a really, really fun meeting. So if you're not a member yet, it's a perfect one to join because you can just watch the hijinks.
Absolutely, yeah. We always have fun at this Christmas meeting.
Yep.
So we've got that. Then January is pupillage season. Pupillage gateway opens, so you get to fill in all those fun application forms.
Yep. So is the gateway open now? I think you can see the vacancies, but you can't apply yet.
Yeah. So that's when people apply. So we thought, well, let's put on some great sessions for people. So we've got our pupillage event, 2-night event. It's a bit like WrestleMania becoming a 2-night event. You've got this as a 2-night event now.
If you played a drinking game and took a drink every time John mentions wrestling, you'd be drunk half the time.
Hey, do you know what? I've got.
Although this is your first mention.
This episode. Yeah.
Give you that.
Yeah. So anyway, it's a 2-night event. It's a bit okay. I'm trying to think of something else. It's a 2-night event. See, there's no example. It was the perfect example. That's why it fitted so well.
You can keep it.
Okay, all right. So anyway, it's a 2-night event. And night 1 is pupillage mentoring. So for those who are lucky enough to get a place, and we don't do any of this silly, let's fill in an application form, or let's see if you've got all this great experience to give you more experience. It's kind of an egg and a chicken kind of situation. No, we don't do any of that business over here. We're all about first come, first serve. Just good British queue.
Yes.
So anyway, if you're lucky enough to get a place, it is a mentoring evening. You get a 15-minute one-on-one direct mentoring session with a barrister. Put any questions to them that you like. Try and focus them on the profession, because it's a bit of a waste of time if you start asking them about
what's your favourite colour
and who's going to win the World Cup and all the rest of it. So use your time effectively. So you get 15 minutes with a barrister, and you can still sign up and join the waiting list, because we are adding more places all the time as we get more barristers for the session. Night 2 is a Q&A event. So we've got a panel of 10 barristers. It'll be about an hour long, and you go on and you can put questions to the barristers. Once again, I'd probably focus them on pupillage applications and interviews and all the rest of it, rather than who's your favourite actor or whatever.
And my advice would be to submit your questions in advance, because we've got so many already. We will, we'll group them together, so we'll cover them in bulk, etc., because there's a lot of repeat questions, but we've got that many. I don't think we'll be able to take many from the audience on the night, because we've got so many to get through.
No. Couple more events that we've got coming up. We keep busy to give you guys as many opportunities as possible, give you the opportunities we didn't have.
Indeed.
So, Pupillage Fair, we had the Northern one in September of last year.
We did.
We are probably going to be announcing the date in January and launching sign up, so you can start signing up for that.
Yeah.
Well, actually, you can start signing up now. To be fair,
you can pre-register now. The website's live.
Now, but we'll properly announce the date in January. and our flagship event, the National Speed Mooting Competition.
I forgot about that then. We're doing so many things. I was like, what else is there?
You forget about like the main thing.
The main thing, like
the
where our
reason
roots
that we
came from.
exist.
Yeah.
If you're playing a drinking game, this will be your second chance to drink. This is the WrestleMania of speed mooting.
Told you.
So, we've got the date set. So we'll probably be launching that in the next week or so.
After our bail application competition.
After the bail application competition this weekend. So if you're taking part in that this weekend, good luck. And I reckon next week maybe we'll be launching sign up for the National Speed Mooting competition. So keep an eye out. It's going to be a fun competition.
And if you're not already, make sure you're on our mailing list, speedmooting.com/contact.
Yeah.
Because the mailing list, as always, will get first dibs before it goes public.
Definitely.
And like this pupillage event, our mailing list took all of the spaces and crashed our website very, very quickly. So if you want a chance to sign up and make sure you get a place, make sure you're on our mailing list.
Yeah, definitely. I think that pretty much covers most things, doesn't it?
I think it has to, John, because I've got to go. It's Thursday afternoon. I've got to edit this for Friday morning.
Okay, well let's wrap it up quickly then. So, usual things. If you're still listening at this point, you are one of our real listeners, I would say. If you're still listening at this point, drop us a comment in the comments below. And I think this week the comment has to be
Paralegal?
Paralegal. Yeah, paralegal. So drop us a comment, paralegal, down below. And as ever, any questions for future shows, give us an email, info@speedmooting.com, drop a comment, or tag us online. If you are listening, snap a screenshot and tag us at speedmooting. And if you've got a few seconds spare, give us a rating, give us a 5-star rating on Spotify.
Or give us a thumbs up on YouTube.
Thumbs up on YouTube, that's always much appreciated.
And don't forget to subscribe.
So that's the end. I will stop speaking now. I've enjoyed recording. Have you enjoyed recording, Hayley?
I've enjoyed recording it, John.
Perfect. I hope you've enjoyed listening. And until next time, cheerio.
Bye.